Okay, so during the time this phone call had come in from the defendant, how long did you remain on the phone?
It was only a couple minutes.
Okay, you didn't hang up and then call back?
Not to my memory.
Okay, so meaning when you got that call from there, you were in the condo and you walked into the room?
Yes.
Okay, when you said, just repeat your answer, what did you say after picking up, determining this gun was there?
I just confirmed that it was there.
And so when you say, I confirmed it, what did you actually say?
It was there. It's there.
It's there, okay. And what did he say?
And he said, all right.
Okay, anything else about that conversation?
Nothing else.
Okay. Now, that was on what date, sir?
That was the day before I left, so it had to be the 30th.
30th of April?
Correct.
And that was what year?
I'm sorry?
What year was that?
Oh, 2013.
Okay, the next day, what do you do?
I fly back out to Connecticut.
Okay. And when you fly back out to Connecticut, at some point after that, do you have any communication with the defendant?
Just, a random text to thank him for, the vacation.
Okay. And now at some point thereafter, were you contacted by an agent of the ATF, Alcohol, Tobacco, Firearms unit, as well as a state trooper?
Yes.
And did they introduce themselves to you?
Yes.
And do you recall who you met with?
Can't recall them, but Mike Grasso is one of them.
Okay, and is he with the ATF?
Correct.
Okay. And did he, excuse me, conduct an interview of you?
Yes, him and two other men came to where I work and interviewed me.
Okay. And did you, they asked you questions about some of the subject matter we're addressing here today?
Yes.
Do you know what caused them to come to speak to you?
They knew that I was hanging out with Aaron.
Okay, do you know how they knew that?
Maybe through phone records.
Okay. Do you recall being asked about a particular phone number in your phone records, whether you knew an individual, whether you actually had made a call?
Yes.
Okay. And do you know the name Oscar Hernandez?
I do not.
Okay. Did you ever make a phone call to an individual by the name of Oscar Hernandez?
Never.
Was any of that subject of your interview with the ATF?
Briefly, yes.
Okay. And as a result, were questions put to you about this trip to California?
Yes.
Okay. And how long did that interview, your initial interview with ATF agent Michael Grasso, last?
It was probably a little over an hour.
Okay. And after that, did they leave?
Yes.
Where was that interview conducted?
Yard Metals.
I'm sorry?
Yard Metals, where I work.
Okay. And that's in Connecticut?
Yes.
And sometime after they left, did you do something?
Yes.
What did you do?
I gave them a call.
Okay. And what caused you to call them?
Because the conversation that I had with Aaron Hernandez about his gun, I told him that.
Oh, okay, but let me ask you this. During that first hour conversation, did you mention what has been the subject of some of my question about Aaron telling you he had a .45?
I'm sorry?
Sure. When you first met with the ATF for that hour, ATF agent Grasso, during that first hour, had you made any mention about Aaron telling you that he had a .45?
Yeah, I must have described it as him referring it as heat or fire.
Okay. Did you leave out some part of what you've indicated today in your initial interview?
I left out the fact that I felt the gun, a gun.
Okay. And so after the interview ended, sometime, how long after did you call him back?
A couple minutes.
And what caused you to call him back?
Because I was leaving out information.
Okay. And as a result of that, were you then re-interviewed?
Yes.
And did you tell them about, well, what else did you tell them at that time?
Everything that we discussed today.
Okay, which is about your trip?
Yes.
And then the statements that were made in the white Charger?
Yes.
And also then the phone call after he left about checking for this item in the nightstand?
Yes.
Okay. Now, you've been interviewed by the ATF, and you've also been interviewed by a mass trooper, or strike that sergeant, as well as appeared before the Bristol County Grand Jury. Is that right?
Yes.
At any time, did you ever indicate that you actually saw the item?
I've never, no, I did not see it outside the black shirt.
Okay. So at times when you were questioned at the grand jury, and again, you and I have met, is that right?
Correct.
Have you ever told me that you personally saw the gun, like with nothing around it, just in your hands?
Never told you that.
And do you recall being asked at the grand jury after they had left, this would be at page 17, line 18, and how did you hear from him? You answered, Aaron called me, question, and when he called you, what did he say? Answer, he asked me to check his nightstand to see if it was there. That's what he asked. And what I saw was a gun, a big gun wrapped in a black shirt. Do you recall that?
Yes.
Is that truthful testimony?
That I saw it wrapped in a black shirt.
Okay.
Yes.
Did you ever intend that to mean that you actually saw the gun without the shirt?
I didn't intend that to mean that.
Okay. When you and I had spoken before that grand jury appearance, is that true?
Yes.
You had never suggested that to me. Is that true? Meaning that you saw it without the shirt in your hand?
Oh, I've never suggested that I saw it
Okay.
bare.
If I could have one moment, Your Honor. And sir, okay, thank you, sir. I have nothing further, Your Honor.
Good afternoon, Mr. Paradis.
How you doing?
Doing great, thank you. Sir, you testified on direct examination from the ADA that you were in California because Mr. Hernandez paid your way there. Is that correct?
Correct.
And can you tell me, sir, whose idea was it for you to go to California?
I think it was a mutual thing. You know, we were talking a little bit, spent some time, didn't see him in a while, so figured it was a good opportunity.
And are you married? Do you have a family, sir?
No, I don't.
So you were free to go to California at sort of short notice?
Yes.
And when you arrived in California, I believe you said that you drove around with Mr. Hernandez in a white Charger.
Correct.
Could you describe that vehicle for us, please? For example, how many doors did it have?
4-door sedan.
A 4-door sedan?
Yep.
And when you drive around, where were you seated, sir, in this car? Did you move around? Were you in the front? Were you in the back?
Just the back seat.
So you were always in the back seat?
Yes.
And you referenced on direct examination that maybe Mr. Hernandez made some statements while you were in the car. Is that correct?
Yes.
When you're in the car in that Charger, sir, was there any music playing?
We had music playing.
What kind of music, sir?
Rap.
Rap?
Hip-hop.
Could you describe the volume when you were traveling around with Mr. Hernandez, and I believe you testified Mr. Wallace? Was that rap music being played in sort of hushed tones, or was it at some volume?
I would say a medium volume.
And you sat in the back seat.
Correct.
And I'd like to ask if I could, tell me a little bit about this statement you said you overheard regarding heat or fire. Could you describe that, sir?
Yeah, you know, he just referenced heat or fire that he had on him.
Was he talking to you?
He was just talking in general.
Did you ask him if he had heat or fire?
I did not.
Did Mr. Wallace ask him if he had heat or fire?
Not that I heard.
You just heard Mr. Hernandez say, "I have heat or fire."
Yes.
And from that, sir, did you make some assumptions?
Yes.
What assumptions did you make?
I assumed he had a gun.
And why did you assume he had a gun as opposed to, say, heated seats?
He said it was under his seat.
Now, when you were asked about your interview with the ATF, Agent Grasso, a Massachusetts State policeman by the name of Sherburne, Detective Elliott, correct?
Correct.
And you said that after they left you, left your place of employment, you initiated a contact with them. You called them. Is that right?
Yes.
And you wanted to add to the facts that you had already provided.
Yes.
And did you believe, sir, that the facts you had already provided were complete?
No.
Well, in what way were they not complete, sir?
I didn't mention the call with the nightstand.
Well, you also didn't mention him having a .45 under the seat, did you, sir?
No, but
No, sir, that's just a yes or no.
No.
Did you tell the special agent from the ATF, the Massachusetts State Policeman, and Detective Elliott that in that white Charger, Mr. Hernandez said he had a .45 under the seat?
I did afterwards, after our interview,
When was that, sir?
with the phone conversation.
Well, when you met with the agent, he actually produced a memorandum of what you said, sir. Did you know that?
Yes.
And have you ever seen it?
I haven't.
It's not been shown to you during your preparation sessions with the DA's office?
You know what? I take that back. I definitely have seen that.
And is it your testimony, sir, that you told the ATF agent, the Massachusetts State Trooper, and Detective Elliott that Mr. Hernandez said he had a .45 under the seat of the white Charger? Is that your testimony, sir?
I can't recall when I said it, if it was at that point, but I have mentioned it over the last year.
Well, let me draw your attention to what Special Agent Grasso wrote, sir. Special Agent Grasso wrote that Mr. Paradis said A. Hernandez mentioned having guns, but never in detail, nor did he see
That's correct.
A. Hernandez or Wallace with any firearms. That is, you didn't see Aaron Hernandez with any firearms, did you? That's what you told Agent Grasso.
That's correct.
And you never saw Ernest Wallace with any firearm. Isn't that right?
That's right.
And Special Agent Grasso says, Mr. Paradis said A. Hernandez told him he, A. Hernandez, had a .45 caliber firearm. Is that right?
Yes.
Mr. Paradis stated they were in A. Hernandez's vehicle when A. Hernandez mentioned, quote, "I got fire," then later said, "I got fire under the seat." Mr. Paradis assumed this meant there was a gun under the seat of the vehicle.
Yes.
Is that an accurate statement of what you told the agents?
That's an accurate statement.
Mr. Paradis never asked or discussed if A. Hernandez legally or illegally possessed these firearms. End of paragraph.
Yes. That makes sense.
So, Mr. Paradis, I'm going to ask you one more time. Did you tell the special agent from the ATF that Mr. Hernandez said that he had a .45 under the seat of the white Charger,
He made reference to a heater fire.
but not a .45 under the seat?
So, a moment ago, I'm sorry, are you saying you didn't tell the officer that, or you didn't, he never said that?
I don't recall the conversation with the officer to be exact, but I've heard 45 being mentioned while being in LA.
But that's, a few minutes ago, you testified, I thought, that while driving, Mr. Hernandez said he had a .45 under his seat. Is that no longer your recollection?
While driving, he never made reference to a 45, just using the terms fire or heat.
So when did the .45 reference come up?
It must have came up sometime, the 4 days, 5 days that I was out there,
What do you remember him saying about a .45?
that he had one.
Yeah, Your Honor.
Me.
And Mr. McCauley asked you about a second interview that you had with the Massachusetts State Police involving Trooper Baker. Do you remember that, sir?
Yes.
And in that conversation with Trooper Baker, once again, sir, you never told Trooper Baker that that Mr. Hernandez said he had a .45 under the seat.
Yes, that's all right.
And when you testified in the grand jury, sir, you were asked a question. Question, where did he say the .45 was? Answer, page 10-32. Answer, he made reference to it being under the front seat. That's different, isn't it, sir?
Yes.
Different from the two earlier versions you told.
Overall.
Now, going back to that interview you had at your place of employment, Mr. Paradis, you mentioned that the agents came there and interviewed you. Is that correct?
Yes, they came unannounced.
How did you find out about that interview?
The interview?
Yes, how did you find out that they were coming to interview you?
I didn't find out they were there. They called me to the front.
They called you to the front and just showed up? Three police officers just showed up at your place of work?
Yes.
That surprised you?
Yes.
Make you uncomfortable?
Of course.
Did other people know about it?
Of course.
Where did you meet with them?
In a side room.
Did you have privacy there, or will you be able to be viewed from the outside by other coworkers?
There was windows, so yeah, you could see me.
So people walking by could see you being interviewed by three people.
Yes.
Did they have their shirts off? Did they have weapons visible? Could people tell they were police officers?
I can't recall whether or not they had their sidearms, but you can tell that they were police officers.
Now, the police officers that you were meeting with, one was from the Bureau of Alcohol, Tobacco, and Firearms. Is that correct?
Correct.
And you testified on direct that you're a gun owner, so you know what the Bureau of Alcohol, Tobacco, and Firearms is, don't you?
Correct.
That's the federal agency that has overall responsibility for the regulation of firearms in the United States.
Correct.
And you were meeting with a Massachusetts State Police officer, that's right?
Correct.
And a detective from North Attleboro, Massachusetts.
Yes.
Did they tell you they were part of a homicide investigation?
It's been a while, so I can't really say that to fact.
But clearly, when you met with them, you knew it was a serious matter.
Yes.
And you wanted to be very accurate and very complete in what you told them.
Of course.
But you did not tell them about this call from Mr. Hernandez in that first interview, did you?
Correct.
You only brought that up on a phone call you initiated after they left.
Correct.
And after they left, you called Trooper Shervin, is that right?
Correct.
And why did you call him as opposed to the ATF agent, Mr. Paradis?
There's no reason. I just called the number that I was given.
And you told Trooper Shervin that you left something out of the session that you had just had, correct?
Correct.
And what you wanted to add was some information about an exchange you had with Aaron on April 30th, I believe you testified?
Correct.
And you told Trooper Shervin that you had been staying with Aaron at his condo in Southern California, correct?
Correct.
And that Aaron and Mr. Wallace left to come back to the East Coast.
Correct.
And it was your understanding, sir, was it not, that Mr. Hernandez was coming back to start training camp for the Patriots?
Yes.
But Mr. Hernandez, Aaron allowed you to stay in his home for an extra day.
Correct.
And it was during this period of time that you received a telephone call. Is that correct?
Correct.
Now, on direct examination, you testified, I believe, that you testified that Mr. Hernandez called you and asked you to check on a gun?
He called me to check on it.
Now, is that what you told the Trooper Shervin when you were trying to supplement and be complete about the interview you had just completed down in Connecticut at Yard Metals?
I told him about the call, yes.
Did you say that Mr. Hernandez called you and asked you to check on it?
To quote myself, to remember what I exactly said, I can't recall that.
Well, perhaps it would refresh your recollection if I shared with you what Agent Grasso said Trooper Shervin heard from you.
Sure.
This is page 3 of 3, Mr. McCauley. This is in the Grasso interview memo. Paragraph 19. Mr. Paradis advised that after A. Hernandez left California, he was staying at A. Hernandez condo until the next day. Mr. Paradis received a call from A. Hernandez, who requested Mr. Paradis check A. Hernandez's top dresser drawer to make sure a black T-shirt was in the dresser.
Yes.
Does that refresh your recollection about what you told Trooper Shervin?
Yes.
So what you told Trooper Shervin was that Aaron Hernandez called you and asked you to check a T-shirt in a top dresser drawer. Is that correct?
Yes.
Now, I noticed on direct examination, you used the word nightstand, didn't you?
Yes.
Now, a nightstand and a dresser are two different things, aren't they?
Correct.
But you told Trooper Shervin that you were asked to check a T-shirt in the top dresser drawer.
Correct.
And the dresser was located, Mr. Grasso's report continues from Mr. Shervin, was located in A. Hernandez's bedroom. Mr. Paradis said he went and checked to make sure the T-shirt was in the top dresser drawer. Now, in those sentences I've read, sir, there's no mention of checking it, is there?
No.
The report goes on. Mr. Paradis said he went and checked to make sure the T-shirt was in the top dresser drawer. Mr. Paradis, when he flipped up the T-shirt, felt a firearm. Is that what you told Trooper Shervin?
Yes, I felt it.
Mr. Paradis did not pull the firearm out of the shirt or look at it. Is that what you told Trooper Shervin?
That I didn't pull it out, yes.
Or look at it?
Look at it.
You did not look at it.
Did not look at it bare without a shirt around it.
Without a shirt around it. Now, today you testified that you picked it up, that you held it, that you weighed it, and that you made observation about it, didn't you?
I did feel it.
But you didn't tell Trooper Shervin that, did you?
And if I didn't say it in the report?
You didn't.
I didn't.
I make objection, unless he knows this was being recorded or has had an opportunity to read it.
Well,
The absence of it wouldn't suggest that it wasn't said, right?
it's his recollection.
Mr. Paradis, the report concludes in paragraph 19, Mr. Paradis did not pull a firearm out of the T-shirt or look at it, but he knew a firearm was wrapped in that T-shirt.
Yes.
Is that what you told Trooper Shervin?
Yes.
Now, sir, looking at your previous statements and your testimony today, one fact is clear. You never saw what you believe to be a firearm in that T-shirt, correct?
That's correct.
And in fact, as you just testified again, you didn't pull the T-shirt back or reveal what was wrapped in that T-shirt. Is that right?
That's correct.
Now, when you talked to Sergeant Baker of the state police, you told him that Mr. Hernandez called you and asked you to check the top drawer of his nightstand. Do you remember saying that?
Correct.
And here, for the first time, you mentioned to Sergeant Baker to check, that Mr. Hernandez said to check to see if it was there.
Correct.
Well, when Mr. Hernandez says it, do you have any idea what he was referring to?
It could mean a lot of things.
And when you testified in the grand jury, you again stated that you were asked to check the nightstand. Is that right?
Correct.
Not the dresser.
One and the same.
Sorry?
A nightstand, dresser, I just must have called it wrong, but
And when you testified in the grand jury, sir, you stated, I saw a gun, a big gun wrapped in a T-shirt. Do you remember testifying under oath to that?
yes.
But that's not what you told Trooper Shervin, is it? That you saw a gun, a big gun?
No.
No. And indeed, sir, you didn't see a big gun wrapped in a T-shirt, did you? Just what you saw. You didn't see a big gun wrapped in a T-shirt.
I didn't see that.
You did not see that.
I felt it.
But strike this
I'm gonna
answer as
strike
non-responsive.
that. It's non-responsive. He answered the question.
The question was, did you see it?
Did
And
you
he had
see it? And
a
he answered,
T-shirt.
he
The
did
question-
see it and went on to say he felt it. The comment, "I felt it," is ordered stricken. It's non-responsive. Listen carefully to the question. Just answer the question asked.
Now, Mr. Paradis, with regard to this object that was wrapped in the T-shirt, you stated with some confidence in response to questions on direct that you were certain it was a firearm. Is that right?
Yes.
And that's because you're now saying you picked it up and you held it and you weighed it. Is that right?
Yes.
But, sir, you didn't see the firearm, correct?
Correct.
And you don't know what was in there. If it was a firearm, you don't know what was in there, do you?
Correct.
You'd be speculating to say, for example, it's a .45.
Sustained.
Mr. Paradis, you didn't see what was inside the T-shirt.
Sustained. That's been asked and answered.
You felt the T-shirt.
Sustained. Asked and answered.
Mr. Paradis, aren't you speculating that this was a firearm inside the T-shirt?
Sustained.
Do you know what caliber firearm was inside the T-shirt, Mr. Paradis?
I don't.
Do you know what color the firearm was?
I don't.
Do you know what make the firearm was?
I don't.
Do you know what model the firearm was?
No.
Do you know if it was made of polymer black plastic?
I don't.
Do you know if it was silver, nickel plated with a wooden handle?
No.
Do you know if it was a revolver or a semi-automatic?
No.
I have nothing further, Your Honor.
Sir, you were interviewed by ATF Agent Grasso, is that right? And you indicated in the course of that interview that Aaron Hernandez, the defendant, told you he had a .45.
Correct.
Okay. You also indicated that to Sergeant Baker, is that right?
Yes.
And you also told that to the grand jury, is that right?
Yes.
When you went to that drawer, was there anything else in the drawer?
To my recollection, no.
Okay. So this black shirt or T-shirt and the gun that you handled, felt, were the only items?
Yes, to my knowledge.
And you indicated that a nightstand and a dresser is one and the same, I think you said?
Yes.
And your relationship with the defendant when you were interviewed was what?
A good friend.
Okay. Has that changed from that time till the present?
I haven't spoke to him since.
Okay. But you didn't have any falling out or anything of that nature, did you?
No.
Thank you. Have anything else, Sean?
Nothing else, Your Honor.
Thank you, Mr. Tarrant. I have heard legal argument from both of you on 2 occasions, and I've received briefs from both sides on if you have anything in particular you want to add, I will hear you now.
Your Honor, I was just going to offer to the court, in support of the motion, all the reports, so there's no miscommunication with regard to what's in reports or not in reports. I have 5 items here I'd offer, and those are the reports of Sergeant Baker, ATF Agent Grasso, the grand jury minutes of Robert Paradis, and yeah, I'm sorry, 3. Those 3 reports that relate to his statements.
Your Honor, I do not have an objection, and we just draw the court's attention to those and to read those in conjunction with representations made by the Commonwealth on page 6 and 7 of their factual proffer in the motion.
I don't know if you want to, is Mark on this submission?
Maybe marked as an exhibit for the hearing.
Okay. Thank you.
No, for the hearing.
Your Honor, oh, sorry. Your Honor, if I could be heard just in summary, we believe that the testimony offered today further underscores the arguments that we've made in our papers. This is an attempt to use uncharged conduct in a way that would be extremely prejudicial to the defendant, Mr. Hernandez, and it is an attempt to show propensity. The facts as brought out today and through the supplementary materials that the court will have available to it indicate, one, that this witness is unreliable in what the witness has said, both about Mr. Hernandez's statements about the 45 and also about his statements about feeling this object in a wrapped container inside a closed drawer. We would cite Commonwealth versus Walker for the proposition that there must be some reliability here, Your Honor. The actions must be related in time. There must be a sufficient nexus to the case that is currently being prosecuted. We'd state that in addition to the discrepancies that permeate this witness's testimony, we would add the following facts, which is that this was 3,000 miles away. This was weeks before the homicide of Mr. Lloyd. There is absolutely no evidence of whether or not any firearm that may have been in California could have been transported back to Massachusetts to be the murder weapon. Mr. Hernandez flew commercial. He never returned to California. He went to Patriots training camp. So this is incredibly prejudicial. It's quite different, Your Honor, than the cases that are before the court in the papers filed by the parties, where there were specific observations of a particular defendant with a firearm. In the Otsuki case, for example, where a police officer observed and could describe in detail a firearm that was possessed by a defendant, and that this firearm, with the reliable testimony around it, could be admitted in a subsequent murder case. Here, this is like a carnival game of shadow box where an individual puts his hands into a dark space, feels it, and makes conclusions. And those conclusions are now before this court, and it's before its sound discretion as to whether they would be admitted before this jury. We would submit, Your Honor, that at the end of the day, the balancing that is required under Toro and other cases would indicate that this balance tips in the defendant's favor. This would be incredibly prejudicial to have this touching and feeling admitted before this jury in this case, especially a case where there is a dearth of evidence as it relates to the actual homicide itself. It would invite the jury to engage in speculation about what did this gentleman feel in this drawer, and could it have gotten back to Massachusetts, that would be unfairly prejudicial to the defendant. We would ask that the evidence be excluded.
Thank you.
Your Honor, I would first start with the idea that this is a friend of the defendant, who the defendant flew out to California first class to spend time with for approximately just under a week, and made statements to, I have a .45. He then makes statements when they're going out, I have heat or fire, to which this witness understood that to be reference to a gun under the seat. He's directing, apparently Wallace agrees. Later on, when he's leaving, he calls back specifically to have this witness go into a dresser or nightstand, he says they're one and the same, in his bedroom, open up and make sure it is there. He then, he has special knowledge, he owns a firearm, he picks it up, he described it for the court, the weight of it, the shape, the size. It's the only thing in the drawer that, to his memory. The cases, Atsuki, that was a California, Mr. Atsuki apparently had a gun 2 months prior, was seen in front of a movie theater. That was deemed admissible. The most recent case, Commonwealth versus Edward Corliss, where the court found obviously the relevance of, highly relevant, the defendant's access to firearms short times before. This is 6 weeks before, Your Honor. This is somebody who has no motive. Described, in fact, the ATF showed up and questioned him, and then as a result of that, after they left, he called them to report there was certain information. I would suggest maybe that's what a friend would try and do, because he didn't want to be discussing such matters with the ATF or others. But I don't find in the statements that have been attributed to him in police reports, they all say the same thing. He's never indicated that he was able to see it. There's credibility there. It's not heaping on that he's tried to suggest he did see something and make it better than it actually was. He says, I see it, I know it when I see it. So respectfully, Your Honor, I would suggest it's very relevant and should be admitted.
Thank you. Could I see the exhibits, please? I have previously reviewed the grand jury minutes, and I have reviewed just now the additional exhibits. It is somewhat difficult to summarize the Commonwealth's proffered evidence, since the witness testified in a radically different fashion today, both on direct and on cross-examination. A summary, at least from direct, of the Commonwealth's proffered evidence is that a friend of the defendant, Mr. Paradis, spent several days with the defendant and Mr. Wallace at the defendant's condo in Los Angeles the last week of April of 2013, 6 weeks before the killing of Odin Lloyd. Aaron Hernandez made reference to heat or fire, maybe sometime in the car, but the witness cannot recall exactly. At some point, Aaron Hernandez said he had a particular caliber firearm, a .45, under his seat. He said that while Mr. Hernandez was driving and Mr. Paradis was in the back seat. Asked on direct what was the context of that conversation where he indicated he had a .45 under the seat, Mr. Paradis said, "We were just going out, you know, driving around." Asked during the time that they were out, how many occasions did he indicate he had a .45 under the seat or heat or fire? He said that he couldn't put a number on it, but that it was a couple of times. And he further testified that Aaron Hernandez was driving when he made those statements. By sharp contrast, today on cross-examination, he stated that Mr. Hernandez just referenced heat or fire, asked, but not a .45 under the seat. The witness said no. He said, quote, while driving, he never made reference to a .45, just using the terms fire or heat. Asked when did the .45 reference come up, the witness stated, quote, it must have come up sometime, you know, in the 4 to 5 days I was out there. So the proffer is either that while driving around in the car, the defendant said there was a .45 under the seat as well as heat or fire, or that he didn't say that, and he instead said at some point while they were in Los Angeles that he had a .45 and referred to fire or heat while in the car. Mr. Hernandez left to return by air to Boston with Mr. Wallace the day before Mr. Paradis. Again, the Commonwealth's proffer would be that the witness would testify, as he did today, that shortly after leaving for the airport, the defendant called Mr. Paradis and asked him to check whether it was in his nightstand. Mr. Paradis opened the nightstand drawer where he saw a black T-shirt. He picked the shirt up in his two hands. He could feel a approximately 7-inch, couple of pound gun. Mr. Paradis told Mr. Hernandez, quote, it's there, and Mr. Hernandez said, all right. Paradis at no point saw the gun, to the extent, however, that a jury would credit the testimony that Mr. Paradis either heard Mr. Hernandez say there's a .45 under the seat, or that Mr. Paradis heard Mr. Hernandez refer to having a .45. A jury could infer that the gun that was felt by the witness was a .45. Evidence concerning a weapon that could have been used in the crime as the murder weapon, or at least one that was in the possession of one of the co-venturers during the carrying out of the crime, is admissible in this court's discretion, even without direct proof that the particular weapon was in fact the murder weapon or one carried by one of the joint venturers. Such evidence is relevant to show that the defendant had the means to commit the crime directly or by supplying the weapon to another person with whom he was intentionally participating in the commission of the crime. Where a particular weapon could not, however, have been used in the commission of the crime, its tenuous relevance is outweighed by the likelihood of unfair prejudice to the defendant. This would be the case if the defendant had no ability to access the weapon he may have possessed weeks, months, or days earlier, even if it is the same type of weapon as the murder weapon. The Commonwealth's proposed testimony establishes that Mr. Hernandez and Mr. Wallace left Los Angeles on April 30th without the weapon at issue. The Commonwealth has proffered no evidence that Mr. Hernandez ever returned to Los Angeles before the shooting of Mr. Lloyd, nor evidence that Mr. Wallace returned there or that Mr. Paradis drove or otherwise brought the firearm back to Massachusetts, or that he had it shipped to Massachusetts in some fashion, or that anyone else did so. Absent evidence from which a jury reasonably could infer, not simply speculate, that Mr. Hernandez directly or indirectly retrieved the gun from California, that weapon could not, as a practical matter, have been used in the commission of the crime. Thus, the facts here are very different from Atsuki, where a jury reasonably could infer that a person seen out of state with a weapon brought that weapon into the state. While the Commonwealth need not proffer direct evidence that the gun in California was actually the murder weapon or actually carried by a joint venture, that 45 or that would not be probative of the defendant's means to participate in the commission of the charged murder, because on the facts of this case, there's no circumstantial evidence that the defendant had access to that weapon at the time the murder was committed. The proposition that the Commonwealth need not introduce direct proof that the particular weapon was in fact used in the commission of the crime doesn't eliminate the requirement that there be some evidence from which it can be reasonably inferred that the defendant had access to the weapon in Massachusetts on the date of the murder, and therefore it might have been so used. Because the evidence concerning this particular gun is not probative of the defendant's access to a weapon at the time of the killing of Mr. Lloyd, its admission would be merely suggestive of a criminal propensity or bad character, and its tenuous relevance is outweighed by the potential for unfair prejudice. The court notes that it has allowed testimony of possession by the defendant of a Glock 45 in Florida, testimony of the sighting of a gun and the defendant's possession in Boston the day or so before the shooting at issue, and testimony by persons that they saw a gun that may have been consistent with the size of a Glock 45 in the defendant's residence in the months or days or weeks before the shooting. The prejudicial impact of Paradis's testimony, the court finds, would outweigh its probative value, if any. Commonwealth versus Corliss, that was decided last month and relied on by the Commonwealth, warrants no different result. In that case, the court found no error in the admission of testimony of the defendant's friend that he had seen the defendant with a gun 16 months before the shooting in question, and at the same time saw the defendant actually put bullets into the clip of the gun at the defendant's home. The evidence was found to have been properly admitted on two different grounds, whether the defendant had the means to commit the crime and whether the defendant had knowledge of how to operate a firearm at the time of the shooting. The trial judge in Corliss, unlike this court, concluded that the probative value of the testimony in that case outweighed its prejudicial effect. Unlike this case, in Corliss, the jury had no other evidence of the sighting of any gun that could have been the murder weapon in the actual or constructive possession of the defendant. Unlike this case, in Corliss, the jury could have drawn the reasonable inference that the defendant still had access to the gun seen in his home by the witness. The SJC recognized, therefore, that it was properly admitted to show the defendant had the means to commit the crime. The Commonwealth's argument at the last hearing that in Corliss the court made the point that geographic proximity is not relevant due to the easy mobility of firearms is entirely unsupported by that case. The only time that the SJC in Corliss referred to proximity was in the context of temporal proximity. In referring to the 16-month interval between the witness's observations and the shooting, the court states that proximity to the crime in point of time is an element to be considered in viewing the probative value of the testimony, and it is a factor which should be left largely to the discretion of the judge. The facts in Corliss also make it very clear that geographical proximity was not at issue. The witness in Corliss saw the defendant handling a gun in his home. According to the facts laid out in that decision, the defendant lived in the Roslindale section of Boston, and the killing was in Jamaica Plain. The jury easily could have inferred the defendant still had access to that firearm at the time of the commission of the murder. Furthermore, unlike this case, in Corliss, there was evidence that the defendant was seen putting bullets into the clip of the gun, making it independently admissible for knowledge of how to operate a firearm. Paradis saw no such operation. Indeed, he never saw the firearm. The Commonwealth's argument advanced at the last hearing that Corliss makes the point that mere possession of a firearm is a basis upon which might infer knowledge of its use and operation. Indeed, that Corliss is, quote, very clear on that point, end quote, is entirely unsupported by the reasoning or facts of that case. The Commonwealth's second motion, in limine to admit Robert Paradis's testimony with respect to statements made concerning a 45 or heat, or statements made in the car, is denied. Thank you. The